Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. We've reached the final module, the capstone synthesis. Over the past 6 modules, you've built a comprehensive understanding of trade secret law and protection. You've learned what trade secrets are, how courts define them, and why they're distinct from patents, copyrights, and trademarks. You've explored how to identify and inventory secrets, how to value them strategically, and how to assess the risks they face. You've studied internal risk mitigation through employee agreements, training, and culture. You've examined external risk mitigation through vendor controls, M&A due diligence, and staged disclosure. And you've learned how to enforce trade secret rights through litigation, injunctions, damages, and strategic enforcement choices. But knowledge without integration is fragile. You can master each component, non-disclosure agreements, valuation, audits, injunctions, and still fail to build a cohesive protection system. That's because trade secret protection isn't a collection of isolated practices. It's a system, one where each element reinforces the others, where documentation flows from identification through enforcement, and where legal requirements align with operational realities. This module synthesizes everything you've learned into a unified framework, the Trade Secret Protection Plan, or TSPP. Not just a document, but an operational roadmap that demonstrates to courts, boards, and adversaries that your organization treats secrecy seriously, systematically, and continuously. This lecture introduces the 6 pillars of trade secret protection, the structural elements that every TSPP must include. We'll explore how these pillars connect, why integration matters, what common mistakes undermine protection, and what a well-designed protection plan actually looks like in practice. By the end, you'll understand that a TSPP isn't optional. It's the legal and strategic foundation for every claim of reasonable efforts, and without it, even valuable secrets may be unenforceable. Let's begin with a simple truth. Trade secret law rewards diligence, not entitlement. Trade secret law is unique among intellectual property regimes. Patents grant rights automatically once the USPTO issues them. Copyrights arise the moment a work is fixed in tangible form. Trademarks protect brands through use in commerce, but trade secrets, they exist only as long as you protect them, and only if courts believe your protection efforts were reasonable. This requirement isn't a formality, it's the doctrinal linchpin of trade secret law. The UTSA and DTSA both condition protection on efforts that are reasonable under the circumstances to maintain the trade secret's secrecy. If you fail to meet this standard, you have no trade secret, no matter how valuable the information, no matter how egregious the theft. What does reasonable mean? Courts won't give you a checklist. The standard is context-dependent, flexible, and deliberately vague. A small startup with limited resources faces different expectations than a multinational corporation with dedicated legal and IT teams. A company protecting a single manufacturing process faces different challenges than one managing hundreds of confidential customer relationships. But flexibility doesn't mean unpredictability. Courts look for patterns of diligence, evidence that the company treated confidentiality as a priority, not an afterthought. They want to see policies, training, access controls, non-disclosure agreements, labeling, audits, and enforcement. They want to see that protection was embedded in operations, not just asserted in litigation. And here's the key insight. Courts evaluate reasonable efforts holistically. They don't ask whether you had an NDA or whether you locked the server room. They ask whether you built a system, one where identification, valuation, controls, documentation, and enforcement work together. That system is your Trade Secret Protection Plan. A comprehensive TSPP rests on 6 pillars. Each addresses a distinct dimension of protection, but none stands alone. They're interdependent, reinforcing, and mutually necessary. Pillar 1, identification and inventory. You can't protect what you don't know exists. The first pillar requires mapping your trade secrets, systematically identifying what information qualifies, where it lives, who has access, and how it's used. This isn't a one-time audit. It's an ongoing process that evolves as your business develops new products, hires new personnel, and enters new markets. Identification feeds every other pillar. You can't value secrets you haven't identified. You can't assess risks to secrets you don't know about. You can't train employees on confidentiality if they don't know what's confidential. And you can't enforce rights to information you never documented as a trade secret. In Module 2, we covered how to conduct trade secret audits, how to classify information by sensitivity, and how to build inventories that capture technical secrets, formulas, processes, designs, and business secrets, customer lists, pricing strategies, supplier relationships. Pillar 2, valuation and risk assessment. Not all secrets are equally valuable. Not all threats are equally likely. The second pillar requires assessing what each trade secret is worth, both in absolute terms and relative to the cost of protecting it, and mapping the threats it faces. Valuation shapes prioritization. If a secret generates $10 million in competitive advantage annually, investing $500,000 in protection makes sense. If it's worth $50,000, those same controls may be wasteful. Courts don't expect perfect security. They expect proportionate security, reasonable effort scaled to the value and risk. Risk assessment identifies vectors of loss, insider threats, vendor exposure, cybersecurity vulnerabilities, reverse engineering, and lawful discovery. In Module 3, we explored how to build risk matrices that map threat, likelihood, and impact, and how to use those matrices to allocate resources strategically. Pillar 3, internal risk mitigation. Employees are both your greatest asset and your greatest risk. The third pillar focuses on controlling internal exposure through agreements, training, access controls, and culture. This includes employee non-disclosure agreements and confidentiality clauses that survive termination, invention assignment agreements that clarify ownership, non-compete and non-solicit provisions where enforceable, and exit protocols that recover materials and reinforce continuing obligations. But contracts alone aren't enough. Courts expect training, not just onboarding sessions, but recurring education that reinforces what trade secrets are, why they matter, and what employees must do to protect them. They expect access controls, role-based permissions, need-to-know restrictions, and technical barriers that prevent unauthorized copying or disclosure. And they expect culture, leadership that models confidentiality, policies that are enforced consistently, and incidents that are addressed promptly. In Module 4, we studied how to design JML protocols, which covers joiners, movers, and leavers, how to structure training programs that create documentation, and how to build a culture where secrecy is a shared responsibility. Pillar 4, external risk mitigation. Secrets don't stay inside. They must be shared with vendors, partners, customers, investors, and regulators. The fourth pillar addresses how to manage external disclosure without destroying secrecy. This includes third-party non-disclosure agreements tailored to specific relationships, vendor due diligence and tiered classification systems, cybersecurity requirements and audit rights, staged disclosure protocols for M&A and venture capital, clean team arrangements that segregate sensitive information, and data room controls with watermarking, logging, and time-limited access. External risk mitigation recognizes that secrecy and collaboration aren't opposites. They're complements. You can share secrets safely if you impose controls, document restrictions, and verify compliance. But if you share indiscriminately, without non-disclosure agreements, without access logs, without follow-up, courts will conclude you didn't value the information. In Module 5, we examined how to draft effective third-party agreements, how to conduct vendor security assessments, and how to structure due diligence in transactions where secrets must be disclosed to close deals. Pillar 5, enforcement readiness. Protection doesn't end with prevention. The fifth pillar ensures that if misappropriation occurs, you can prove it and respond decisively. Enforcement readiness includes documentation systems that track what was protected, when and how, incident response protocols that define roles, timelines, and escalation paths, forensic capabilities to identify what was taken and where it went, legal strategy for choosing between state and federal court, injunctions and damages, and preservation of evidence through litigation holds, system logs, and witness interviews. Courts are skeptical of companies that claim trade secrets only after theft. They want to see that secrecy was treated seriously before litigation, that the information was labeled, access was restricted, and violations were addressed. Enforcement readiness means building that record proactively. In Module 6, we covered how to prove misappropriation under UTSA and DTSA, how to obtain injunctive relief, how to calculate damages, and how to make strategic enforcement choices informed by the Calabrese-Melamed framework. Pillar 6, Governance and Oversight. The sixth pillar ensures that the TSPP doesn't become a static document filed away and forgotten. Governance creates accountability, mandates periodic review, and adapts the plan as the business evolves. This includes assigning ownership. Who is responsible for trade secret protection at the C-suite level, in legal, in IT, in HR, and in business units? Establishing a trade secret governance committee that meets quarterly to review risks and update plans, defining metrics that measure whether protection is working, building review cycles, monthly for incidents, quarterly for governance, annually for comprehensive audits, and trigger-based reviews for M&A, key departures, suspected breaches, and major launches. Governance ensures that protection is a continuous process, not a one-time project. Courts give weight to companies that demonstrate ongoing vigilance, not just initial compliance. The 6 pillars aren't independent silos. They're mutually reinforcing. Understanding how they connect is what separates compliance from strategy. Inventory feeds risk assessment. You can't assess threats to secrets you haven't identified. The inventory from Pillar 1 provides the foundation for the risk matrix in Pillar 2. If you know that your customer list is stored on a shared drive accessed by 50 employees, you can model the insider threat. If you don't know where it lives or who sees it, risk assessment becomes guesswork. Valuation shapes mitigation priorities. Not every secret deserves maximum protection. Pillar 2's valuation determines how much to invest in Pillars 3 and 4. Crown jewel secrets, those with high value and high risk, demand intensive controls, dedicated servers, limited access, encryption, audit trails, and tailored non-disclosure agreements. Routine secrets, low value, low risk, get baseline measures, standard confidentiality clauses, general training, and role-based access. Strategic resource allocation means protecting what matters most, not protecting everything equally. Internal controls enable external disclosure. You can only share secrets safely, Pillar 4, if you protect them internally, Pillar 3. A vendor who receives confidential information under an NDA will ask, how do you protect this? If your own employees don't sign non-disclosure agreements, if training is sporadic, if access is unrestricted, the vendor may reasonably conclude that the information isn't actually secret. Courts make the same inference. If you don't protect secrets inside your own organization, why should third parties be bound by confidentiality obligations? Documentation throughout supports enforcement. Pillars 1 to 4 generate evidence that Pillar 5 depends on. Every inventory entry, every training log, every NDA signature, every access control policy, every vendor audit, these become exhibits in litigation. They prove that the trade secret existed, that it was valuable, that it was treated as confidential, and that reasonable efforts were taken to protect it. Without documentation, even the strongest claims collapse. With it, enforcement becomes credible. Governance sustains all pillars. Pillar 6 ensures that Pillars 1 to 5 don't decay. Secrets evolve. New R&D creates new information. Old secrets become obsolete or public. Threats evolve. New employees, new vendors, new competitors, new technologies. Controls decay. Policies get stale. Training becomes rote. Vigilance fades. Governance creates feedback loops that detect these changes and trigger updates. It ensures that protection isn't just designed well, it's maintained well. Even well-intentioned companies make predictable mistakes when building trade secret protection plans. Understanding these failures helps you avoid them. Mistake 1: over-engineering. Some companies create policies so complex that no one follows them. They require 10 signatures to access a file, 5 levels of classification, mandatory training every month, and approval workflows that take weeks. The result? Employees find workarounds. They share passwords, store files locally, or skip protocols because compliance is too burdensome. Courts don't reward complexity. They reward effectiveness. A simple, consistently followed policy beats an elaborate, ignored one. Mistake 2. Under-resourcing. Other companies draft beautiful policies, comprehensive, well-written, legally sound, but allocate no budget or personnel to implement them. Training doesn't happen. Audits don't occur. Technology doesn't get upgraded. The TSPP exists on paper, but not in practice. Courts see through this. They ask, did you act like secrecy mattered? If the answer is no, if the policy was aspirational rather than operational, protection fails. Mistake 3. Static plans. Many companies build a TSPP once, often during a funding round or litigation scare, and never revisit it. Years pass. The business grows. New secrets emerge. New threats appear. But the plan stays frozen. Trade secret law requires ongoing, reasonable efforts. A protection plan that worked in 2020 may be inadequate in 2025. Governance, Pillar 6, prevents this failure by mandating regular reviews and updates. Mistake 4. Siloed execution. Some companies treat trade secret protection as a legal function. The legal team drafts non-disclosure agreements and policies, then assumes the job is done. But if IT doesn't implement access controls, if HR doesn't conduct training, if business units don't enforce policies, the plan collapses. Protection requires cross-functional collaboration. Legal, IT, HR, and operations must work together, each contributing expertise, each accountable for outcomes. So what does a functioning trade secret protection plan actually contain? Executive summary, 1 to 2 pages for board and C-suite, describes why trade secret protection matters, what the company's crown jewel secrets are, what the top risks are, and what resources are allocated. Crown jewel inventory, detailed appendix, lists the company's most valuable trade secrets, classified by type, technical, business, strategic, location, databases, servers, physical files, access, who can see it under what conditions, and valuation, estimated competitive advantage or replacement cost. Risk matrix, visual tool, maps threat vectors, insider, vendor, cyber, reverse engineering, against likelihood and impact, with mitigation strategies assigned to each high-priority risk. Responsibility matrix, organizational chart, identifies who owns trade secret protection, CLO for legal strategy, CISO for cybersecurity, CHRO for HR policies, business unit leaders for operational compliance, and the governance committee for oversight. Incident response protocol, operational playbook, defines what happens in the first 24, 48, and 72 hours after a suspected breach, who investigates, who makes legal decisions, who controls communications, and what evidence must be preserved. Review schedule, governance calendar, specifies when the TSPP is reviewed, monthly for incident debriefs, quarterly for governance meetings, annually for comprehensive audits, and trigger-based for M&A, key departures, or suspected breaches. A well-designed TSPP is usable, not a 200-page legal treatise, but a practical tool that guides decisions, allocates responsibilities, and creates accountability. Let's recap. Trade secret protection is a system, not a checklist. It rests on 6 pillars: identification and inventory, valuation and risk assessment, internal risk mitigation, external risk mitigation, enforcement readiness, and governance and oversight. These pillars are interdependent. Inventory feeds risk assessment. Valuation shapes mitigation. Internal controls enable external disclosure. Documentation supports enforcement. Governance sustains all of it. Common mistakes: over-engineering, under-resourcing, static plans, and siloed execution undermine even well-intentioned efforts. Avoiding them requires cross-functional collaboration, proportionate investment, and continuous attention. A well-designed TSPP includes an executive summary, crown jewel inventory, risk matrix, responsibility matrix, incident response protocol, and review schedule. It's not a legal formality, it's an operational roadmap that proves reasonable efforts to courts, deters adversaries, and protects competitive advantage. In the next lecture, we'll move from design to implementation, how to operationalize the Trade Secret Protection Plan assign accountability, allocate resources, and ensure that protection lives in practice, not just on paper. Thanks for listening. See you in the next lecture.